A judge in Brazil has ordered Apple to pay a customer more than $1,000 for moral damages for not providing a charger with its iPhone. Most people will know that Apple stopped providing accessories, including the charger and headphones, from 2020 with the release of the iPhone 12. Apple argued that it stopped providing such accessories to help prevent damage to the environment, but the judge didn't accept that argument, saying that the chargers are going to be sold anyway. The judge said that Apple effectively forced the customer into a tie-in sale where they had to purchase a second product from Apple's exclusive manufacturer, without which the main product did not serve the purpose for which it was manufactured and intended. The judge gave Apple 10 days to comply with the order, which included providing the customer with a charger for the iPhone. And this raises a very interesting question with regard to the law of England and Wales, because the Consumer Rights Act 2015, which governs consumer purchases from the 1st of October 2015, implies terms into every consumer contract, including that the product must be fit for purpose and must be of satisfactory quality. And this, of course, applies to the entirety of the contract. So one might argue that the purchase of an iPhone which doesn't come with a charger may not be fit for purpose if it doesn't come with a charger, because you can't charge the iPhone without making another purchase, or unless you already have a device or a computer or something else which is going to charge that phone without making that second purchase. So whilst I'm not currently aware of any such claims against Apple in the United Kingdom vis-a-vis the product not being fit for purpose because it's not being supplied with a charger, I would be very interested to see what a court would say if this argument were brought to court to say that a contract for the purchase of an iPhone without a charger renders it not fit for purpose for the purposes of the Consumer Rights Act 2015. For argument's sake, if there was an express or even implied term in the contract to purchase a phone from Apple that you had to buy a second device to make it work, my view is that such a term would be unfair and thus unenforceable, because it shifts the balance of fairness to Apple rather than the consumer. In other words, it's unfair to the consumer that they would have to buy another product to make this one product work, especially considering the price of these phones, because if you go for the iPhone 13 Pro Max with 1 terabyte of storage, this will set you back £1,549. Rather expensive for a device that doesn't come with a charger that charges it. So here's my suggestion to you: if anyone is desperately upset by this fact and wants to test this out in court, which is most likely to be allocated to the small claims track because the value will be not more than £10,000, I might be persuaded to draft the particulars of claim for free for you to take Apple to court. Let me know in the comments what you think about all this, maybe hit me up by email, and who knows, maybe there'll be a test case that ultimately forces Apple to put the charger back in the box. So I hope you found that interesting, and thank you for watching.